Welcome back to One Stop Law. Now, in our previous lecture, we had studied about mistake and effect of mistake on the contract. To be specific, we just completed the first kind of mistake, that is effect of mistake of law on the contract. A quick recapitulation of that thing is that mistake can broadly be of two kinds, mistake of law and mistake of fact. And mistake of law is again of two kinds, mistake of Indian law and mistake of foreign law. We learned that when there is a mistake as to the Indian law, the law of the land, basically the native law, then a person cannot get any excuse. He cannot avoid the consequence of the contract, and the contract is valid. He has to bear with its consequence. And when it comes to mistake of law, as to a foreign law, then it is treated as a mistake of fact. So we will look into that second category of mistake, that is mistake of fact, in this video. Let's get started. Now the next kind of mistake is of mistake of fact. We just learned that mistake of foreign law is also treated under mistake of fact. So mistake of fact again is of two kinds. It can be a bilateral mistake or an unilateral mistake. Now what is a bilateral mistake? Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement, then it is a bilateral mistake, and in such case the agreement is void. Now there are two essential ingredients to bilateral mistake, that is the mistake must be mutual, that is both the parties must be under mistake. It is not one party's mistake. And second is that the mistake they have made must relate to a matter of fact essential to the agreement, that is it is not something very unessential to the contract. It must be relating to a fact which is material for the contract. Why this is void, I will tell you with an example, because if you remember, we learned that consensus addendum is essential ingredient of a valid contract, that is meeting of minds. Now just suppose that if both the parties are under mistake, we are talking about bilateral mistake, that is both the parties are under a mistake regarding a fact which is essential to the contract, then can we say their minds met at any point? Like suppose A wants to sell his house to B. Now A has two houses in the city itself, in say Calcutta. So A has house 1 in his mind and B wants house 2. So can we say that there was any consensus addendum between the two parties? No. So there is another better example, when A agreed to purchase B's motor car which was lying in B's garage. Unknown to either party, the car and the garage were completely destroyed by fire a day earlier. The agreement becomes void. So you see, in both these cases, in the first case, when the example I gave you about the house, there was no consensus regarding house in both A and B's mind. A was thinking of one house and B was thinking of another house. Therefore, both the parties are under mistake, no meeting of minds, and the contract is void. This is a bilateral mistake. The second example I told you about this selling a selling a car in a garage, and both unknown to both the parties that garage had caught fire last night, and both the garage and the car are now not in existence. So how can they now enter into this contract or effectuate this contract? So these are examples where both the parties are under common mistake. Now as you can see, mistake of fact, which is a bilateral mistake, can be of two kinds, that is mistake as to subject matter and mistake as to possibility of performance of the contract. So mistake of subject matter, the examples I just gave you, like if the contract is about selling or buying of a horse or say a house, suppose that both the parties think of one house, I mean two separate houses, then it is void. Or say suppose if it is about the selling of a horse, the horse has already died, that is the subject matter does not exist at all. Similarly, it can be again in respect to the price of the subject matter concerned. Suppose A has one price in mind and B has another price in mind, then also it becomes bilateral mistake and the contract becomes void. Another way can be, there may be two identical things of the same name. So suppose A wanted to buy cargo from a ship of B which was named say uh, cargo cargo 100. Okay, I'm giving you a blunt example. Whereas B had two ships, of the same name. So A had one ship in mind and B had another ship in mind, and the confusion was because they both had the same name. So again, bilateral mistake and the contract becomes void. The second kind of impossibility in case of bilateral mistake is when there is a mistake as to the possibility of performing the contract. So a consent to the contract is nullified if both the parties believe that an agreement is capable of being performed when in fact it is not the case. So I just gave you the example of that uh, car in the garage, or say the horse. A wants to sell his horse to B, but A it's not known to A that suddenly his horse died the last night. Okay, so the subject matter is not in existence, and therefore the performance of the contract is impossible, and therefore both the parties are considered to be under the common mistake, because if had they known that the horse has died, both of them had not entered into such contract. So these are examples of mistake of fact, specifically bilateral mistake, where both the parties are under a mistake and therefore there is no meeting of minds and the contract is void. The effect of bilateral mistake on a contract is that the contract is void and it has no enforceability in the court of law. Coming to the final category of mistake, that is mistake of fact in the sense of an unilateral mistake. That is, unilateral mistake means when in a contract only one of the party is mistaken regarding the subject matter of the contract, and in such case, because one party is under some mistaken belief, it is his fault, so the contract cannot be avoided on this ground. So a unilateral mistake is not allowed as a defense in avoiding a contract unless the mistake is brought about by the other party's fraud or misrepresentation. So there is some exception, we will come to that, but as of now just learn or try to understand that because one party is under mistake, there is not both the parties mistake. One party is very clear with the thing he wants, or he is very clear in his mind and head that he wants this, or this is the term of the contract, or this is the thing he wants to enter into with the other party about the contract, whereas the other party has some mistaken belief, or he is under some mistake or wrong impression. Now that is his fault, because this is not both parties mistake. One party is very clear in his mind about the contract, so the contract will be given effect to. An unilateral mistake is no defense and the contract is enforceable. To give you an example, suppose A offers to sell his house to B for an intended sum of say rupees 44,000. Okay, but my mistake when while writing this offer in pen and paper, A wrote 40,000 in place of 44,000. Now it's completely A's fault, because A has written 40,000. Now he cannot say that I thought of writing 44,000 but instead I wrote 40,000. No, it is your mistake and you have to bear with the consequence. So the house has to be sold to B by A for rupees 40,000 only. So unilateral mistake is no defense and the contract is enforceable under law. However, there are two specific exceptions to it. Number one is when there is a mistake as to the identity of the person contracted with. So actually this is a little bit related to fraud or misrepresentation. Suppose one person deceives his identity. Okay, because it is the fundamental rule of law that if one of the parties represent himself to be some other person than he what his in reality is, there is a mistake as to the identity of the person contracted with him and there is no meeting of minds, but this is not his fault, because the other party kind of misrepresented himself to this person to deceive him. So suppose A intends to contract with B, but he finds that actually he has contracted with C because C has represented himself to be B to A. So in this case, because A took C considering to be B and there A had no fault, it was C who misrepresented himself, represented himself as B to A. In this case, A, although it is A's mistake, an unilateral mistake as to the identity of a person, but because in this case C has induced it by fraud or misrepresentation, in this case A can avoid the contract. And the last exception to unilateral contract is that when there is a mistake as to the nature of contract. Now I'll give you an example. Suppose a person, an old and infirm person, is actually signing a document. He believes it to be a document of he is giving his property on lease, rather, but instead this is actually a document which he is made to sign is made as a document of sale. So you can understand the difference between lease and sell. Sell means your ownership is going, okay, completely, you are no more having any title to the property, whereas if you are signing a document keeping in mind that you are actually leasing in, that means you have in mind that I am still the owner, I am just giving my possession for time being to some person. So there you see, although it is a mistake in the mind of this person, but somewhere it is a mistake which is very pertinent to the nature of the contract, and it is also somewhere induced by fraud or misrepresentation. So where a person signs a document of contract thinking it to be of some other nature, it can be, I give you the example of lease and sell, it can be like a person is signing a document thinking it to be a bill of exchange, whereas it is actually a contract of guarantee, rather he is made a surety for someone. So these are actually documents which completely change the nature of the contract, and the person cannot be burdened with this, because again there is no consensus ad idem. And in this case also, although this is an unilateral mistake, the effect will be that the contract can be avoided if he can prove that he was actually frauded or misrepresented regarding the nature of the contract. So that's all for mistake. And in this video we come to the conclusion of all the factors which affect the validity of consent or free consent to a contract. In our subsequent lectures we will deal with other topics from contract and other laws. Thank you all.